Good afternoon, everyone. Welcome to the Center for American Progress Action Fund. My name's Carmel Martin, and I'm the Executive Vice President for Policy here at CAP Action. I want to thank all of you for joining for a critical discussion about reforming a growing trend of using mandatory arbitration clauses in the fine print of contracts to limit workers' and consumers' rights to sue. Whether they're buying a product such as a cell phone, signing up for a bank account or credit card, attending a college, or even taking a job, consumers are often unaware of hidden and non-negotiable legal provisions. Yet these provisions can give companies a free pass and an upper hand, making it easier to dodge accountability when families are harmed. Instead of going to the courthouse and appearing before a judge and jury, wrong consumers and workers often must appeal to professional arbitrators who are hired by the very companies that committed the alleged wrongdoing in the first place. In recent months, federal agencies, including the Department of Labor and the Consumer Financial Protection Bureau, have already taken steps to limit these arbitration clauses, and others are likely to follow suit. Some members of Congress have also recognized the importance of reforming these clauses, and we're lucky to be joined by two of them today, Minnesota Senator Al Franken and Virginia Congressman Don Beyer. Senator Franken was first elected to the Senate from Minnesota in 2008 and re-elected in 2014. He currently sits on the Health, Education, Labor, and Pensions Committee, the Judiciary Committee, the Energy and Natural Resources Committee, and the Committee on Indian Affairs. Before running for the Senate, he spent 37 years as a comedy writer, author, and radio talk show host, and has taken part in 7 USO tours, visiting our troops overseas in Germany, Bosnia, Kosovo, and Uzbekistan, as well as visiting Iraq, Afghanistan, and Kuwait 4 times. A staunch advocate for consumers and workers, Senator Franken has sponsored the Arbitration Fairness Act, which restores the 1925 Federal Arbitration Act to its original intent. Please join me in welcoming Senator Al Franken.
Thank you, Carmel. Thank you all for coming today, and to our panel of experts. Thank you for your important work in this area. Especially want to thank Vildan Teskey from Minnesota, who has testified before the Senate Judiciary Committee hearing I presided over on the effects of mandatory arbitration. She has represented Minnesota service members who have been treated wrongly by banks and others. At the same hearing, we had Alan Carlson from Italian Colors Restaurant in Oakland. He shared his story about an arbitration clause in his agreement with American Express, which prevented him from joining together with in a class action suit with other merchants to fight back against the American Express's anti-competitive practices. I'm grateful to both Ms. Teskey and Mr. Carlson for their critical role in raising awareness of this issue and in helping others who have been harmed by it. Before they and others kick off the panel discussion, I want to say a few words about the issue and why I care so much about it. Last November, the New York Times published a 3-part investigative series on the pervasive use of forced arbitration, which is a privatized justice system that corporations rely on when their customers or their workers seek justice for being cheated or mistreated. This series, while shocking, illustrated something that I've been saying for a long time, which is that forced arbitration agreements, which are often buried in the fine print of employment and service contracts, severely restrict Americans' access to justice by stripping consumers and workers of their legal rights and insulating corporations from liability. Now, in arbitration proceedings, these corporations write write the rules. Everything can be done in secret without public rulings. Discovery can be limited, making it hard for consumers, employees to get the evidence they need to prove their case. And there is no meaningful judicial review, so that there's really not much a consumer or employee can do if the arbitrator rules against him or her and just gets it plain wrong. Sometimes the arbitrator even comes from the industry that is being sued. During a Judiciary Committee hearing I chaired on this issue in 2011, I heard a story from a doctor who was suing a hospital for gender discrimination. She was forced into arbitration, which was held in the library space of a law firm. When the doctor went into the library, she saw shelves lined with binders that had the hospital's name on it. In this law firm's library. And one day that she arrived, she saw a hospital executive leaving one of the partners' offices. So it seemed pretty clear to her that the law firm and the defendant had an unusually strong relationship, and a relationship that meant that her ability to get justice was severely compromised. And of course, the arbitration ruling went against her, and she said that it made her lose faith in the American justice system. Corporations also use their arbitration agreements to prohibit class actions, making it nearly impossible for consumers to band together to get redress. The prospect of a class action gives corporations real incentive to follow the law, and is often the only way that consumers can achieve justice when they don't. And the prevalence of these clauses is only growing, from nursing home contracts and employment agreements to credit card and cell phone contracts. Corporate America uses forced arbitration clauses to rig the system against ordinary Americans in a wide variety of cases and in agreements that we each sign day in and day out. My staff recently heard from a Minnesota lawyer who represents families with serious injury and wrongful death claims. He told the heartbreaking story of a man who suffered from dementia and was eventually checked into a nursing home. 21 days after entering the nursing home, it became clear to the man's family that his life was in danger. He was rapidly losing weight and had fallen into a coma. He was then sent to a hospital where it was discovered that he was suffering from, quote, profound dehydration, unquote. Unfortunately, the hospital could not correct the harm caused by the nursing home, and the man died shortly after. He was 71 years old. Then, instead of being able to take the nursing home to court, the family was forced to settle their wrongful death claim through arbitration. When all was said and done, the arbitrators actually received greater compensation than the family did. And the nursing home got away with a slap on the wrist. Unfortunately, egregious cases like this Minnesota families are not unusual. Time and again, arbitration clauses stack the deck in favor of big business and against consumers, employees, as if the deck weren't stacked enough already. As the number of these unbelievable stories grows, and just look at this New York Times three-piece series, the need for reform has become more clear and has become more urgent. That's why I have a bill, the Arbitration Fairness Act, that would fix these unfair practices by amending the Federal Arbitration Act to prohibit the use of mandatory pre-dispute arbitration agreements in consumer, employment, civil rights, and antitrust cases. This bill gives Americans a real choice. If a consumer or a worker wants to take his claim into arbitration, then by all means he is free to do so, provided that the corporation is willing to do so. However, if the consumer or employee wants to go to court, that option will once again be available. I was also proud to join Senator Leahy in introducing the Restoring Statutory Rights Act earlier this year to ensure that Americans can enforce their civil rights. Members of Congress and public advocates have fought hard to pass legislation that will protect Americans from discrimination. This critical work is undermined, however, if we strip away their right to go to court and instead force these claims into this privatized civil justice system. But the executive branch also has a critical role to play in addressing the injustices resulting from forced arbitration, and many agencies and regulatory bodies have already recognized the need for reform and are currently working to address the issue through their rulemaking authorities, a step I strongly support. For example, the Consumer Financial Protection Bureau has proposed a rule that would eliminate class action waivers in consumer financial services contracts. The Center for Medicare and Medicaid Services has recognized the need to revise requirements for long-term care facilities participating in Medicare and Medicaid programs to include limitations on the use of forced arbitration. The Department of Education has proposed limiting the use of mandatory arbitration clauses by schools receiving federal financial aid funding. And most recently, the FCC, the Federal Communications Commission, recognized that forced arbitration more frequently benefits the party with more resources and thus asked for comment on whether broadband providers should be banned from compelling arbitration in their consumer contracts. The answer to that question is yes. Now, we've also learned that we always have to be on defense to make sure big business interests don't prevail over those in public. Most recently, this fight was evidenced by a Republican-led effort to eliminate important protections for federal defense contractors who have claims of discrimination or even of sexual assault and harassment against them. This is something that I took action on in my first year in the Senate, successfully, by the way. As this harmful proposal moves forward in the National Defense Authorization Act, I will do everything in my power to combat it. To put it simply, all of these efforts, both legislative and otherwise, are about reopening the courthouse doors to American consumers and workers, because the courthouse doors never should have been closed in the first place. So I want to thank you all for joining me in this fight. I look forward to continuing our work together to restore access to justice for Americans. Thank you very much.
Thank you so much, Senator Franken. Now I'd like to introduce another fierce defender of American consumers, Congressman Don Beyer. Congressman Beyer is serving his first term as U.S. Representative from Virginia's 8th District. He serves on the Joint Economic Committee and the House Committee on Natural Resources. He's ranking member of the Oversight Subcommittee to the Committee on Science, Space, and Technology, and he's a member of the New Democratic Coalition. Congressman Beyer also served as the Lieutenant Governor of Virginia from 1990 to 1998, and he also served as the U.S. Ambassador to Switzerland and Liechtenstein. As ambassador, Representative Beyer was also integral to U.S. Department of Justice efforts to halt the abuses of Swiss bank secrecy by wealthy Americans. As a legislator and business owner, Congressman Beyer recognizes that arbitration clauses aren't just bad policy, they're bad business. So please join me in welcoming the Congressman.
Good afternoon. And Carmel, thanks so much for the kind introduction. Thank you for the invitation. Thank you, panelists, for doing the hard work ahead. It's great that everybody's here to highlight something that's very important, that we eliminate forced arbitration. It was great to be here with Al Franken. Gixzal's leading the charge in the Senate. When I was lieutenant governor, I gave hundreds of speeches every year, which always included a lot of stupid jokes. Cow jokes and pig jokes and Stephen Wright aphorisms recycled. And I needed to hear the laughter, and I often mistook the laughter for approval of my leadership and my advocacy positions. And it wasn't until later that I noticed that Bill Clinton and Barack Obama never tell jokes. White House Correspondents' Dinner is the exception, and they got elected president. And now, the cleverest, funniest man ever to serve, ever elected senator, serves in the most sober and thoughtful way. So Al is really a great role model for me. Hank Johnson is leading this legislation in the House. The Arbitration Fairness Act, of which I am a proud co-sponsor. Hank's another most interesting man. I hope you get him to come to a future meeting. He's the only Buddhist in the U.S. Congress. And so talking to Hank about suffering and desire and mindfulness and inner peace will change your life. I am a proud car dealer. I've been selling and servicing cars for 42 years with a few wonderful sabbaticals in Richmond and Bern, Switzerland. So I want to speak to you today as a businessman about my personal experience with forced arbitration. You may remember that the automobile dealers have been on the consumer side of this debate for a long, long time against forced binding arbitration. For a long time, fighting forced arbitration in the dealer agreements with the auto manufacturers was our number one priority of NADA on Capitol Hill. We dealers did not want to be denied our day in court when our manufacturers or distributors started messing with us. On the other hand, Ford, GM, Chrysler, and others wanted to build mandatory binding arbitration into the dealer agreements so that an arbitrator in Detroit could decide what was fair. No way, we said, and the car dealers ultimately won. But along the way, much of the rest of the corporate world discovered forced arbitration and started including it everywhere. Back on President's Day this year, my wife and I bought a new refrigerator to replace the 30-year-old one that freezes the door shut once a week. And it was a good deal at Best Buy. But when I read the fine print, sure enough, mandatory forced binding arbitration. So I objected to the poor $7.25 an hour salesman who looked helpless, and he called his manager, who pleaded with me that he was forbidden to change anything on the purchase order. There's nowhere he could go to override it. So I had mercy on these guys. It wasn't their policy, and it was a good deal on the refrigerator. So let me offer 3 small points about mandatory forced binding arbitration. First, it's sneaky. And anything sneaky is automatically suspect. These forced arbitration clauses are buried into the fine print of everyday contracts, and before we know it, we're unknowingly giving up our legal rights. Class action bans, generally buried within forced arbitration clauses, require consumers to waive their right to go to court if a dispute arises. And these prevent consumers who've been harmed on a systematic basis from joining together to seek remedies from the offending company. I think everyone knows we should read the fine print, but few of us ever do. And even if we do read it all, which is damn near impossible past the age of 50, most of us won't have enough legal background to even recognize the problem language when we read it. This is exactly why most Americans don't even know about forced or binding arbitration until it happens to them. Second, forced arbitration is unfair. We consumers are being taken advantage of and being denied our legal rights. About 12 years ago, a friend from church won the DC lottery and immediately quit his law firm and opened a small mediation service in Alexandria. So on the front of our dealer purchase orders, in large letters in a red box, we wrote, "In the case of a consumer problem, we encourage you to contact Chris McMurray to mediate. Doing so in no way will bind you to his decisions or prevent you from suing us in court." Now, I'm paraphrasing a tiny bit, but that's exactly what we said and what we meant. While I was overseas, the Virginia auto dealers updated the purchase orders. When I came back, all of our contracts had mandatory forced binding arbitration. Not for long, because the potential hypocrisy was just too pungent. Fairness. Arbitration is heavily weighted in favor of the more powerful party. Not only does the corporation that wrote the contract set the terms of the arbitration, but it often decides on the arbitrator. That means we have a legally enforceable culture that is reinforcing one-sided provisions that unfairly tilt the playing field in favor of one party. And this allows companies to circumvent the courts and bars people from joining together in class action lawsuits. And let's face it, these class action lawsuits are realistically one of the very few tools citizens have to fight illegal or deceitful business practices. And this is concerning and dangerous when we consider that arbitration clauses are increasingly being inserted into consumer and employment contracts. Applying for a credit card, using a cell phone, getting cable or internet service, even applying for a job, you're likely to be faced with a forced binding arbitration contract. Senator Franken mentioned the new CFPB rule. Well, the Consumer Financial Protection Bureau did a bunch of the statistics in preparing for the new rule. So, market share of credit card issuers that include arbitration clauses, 53%. 44% of insured deposits, 92% of prepaid card agreements, 86% of the private student loan market. Of course, you know student loans aren't a problem in America. 99% of the payday loan storefront locations in California and Texas, and I'm sure in Virginia too. And last but not least, among mobile wireless providers who authorize third parties to charge consumers for services, 88% of the largest carriers include arbitration clauses, which represents over 99% of the market. Third, mandatory forced binding arbitration is bad for business. It's unnecessary. What business thrives long by screwing its customers? You know, we've survived 3 generations in 42 years by doing our imperfect best to be honest, competent, and friendly, apologize quickly, and with a servant's heart to deal with every customer. As businesses, we need to be held accountable when we fail. The private attorney general class action system has long protected consumers and workers from poor quality, fraudulent, or even dangerous products, services, and work conditions. And this makes us, when we fix this makes us much more profitable and sustainable businesses and, incidentally, more fulfilled business leaders. You know, in the dealerships, I only seem to get the really, really difficult customers, even in the office and Cannon office building. The 98% of the problems are easily solved at the service counter or the service manager. I only get the hard cases. And when I'm unable to make progress, my standard answer for years has been, look, you choose a third-party arbitrator. There's a bunch in Metro DC. Present them with all the facts, and then I'll accept whatever they decide. And if you don't like their decision, you can still go to court. Almost 100% of the time, we find a solution in 5 minutes. Because but it indicates an element of trust. Of course, arbitration and mediation can be important and meaningful processes. I was privileged to represent our country as a diplomat for 4 years, so I surely believe in the value of discussion. But arbitration must be voluntary and a process that both parties choose willingly. So in the meantime, mandatory forced binding arbitration is a predatory practice that we must outlaw as soon as we can. So thank you for having me here, and I'll turn it over to the experts.
Thank you, Congressman Beyer. And finally, before we turn to our panel of experts to discuss arbitration clauses in depth, I'd like to introduce a small business owner to tell his own story about mandatory arbitration clauses. Alan Carlson is the chef and owner of Italian Colors Restaurant in Oakland, California. He opened his first restaurant in 1986 and has started and run several restaurants in and around the San Francisco Bay Area. Over 20 years ago, he opened Italian Colors with his wife and business partner. Please join me in welcoming Alan.
These are hard to follow. A couple very influent people that know what they were saying. I'm just going to go through my story because I'm on the consumer side of it. Good afternoon, everyone. I'd like to thank the Center for American Progress for the opportunity to share my story here today. As you know, my name is Alan Carlson. I'm the chef and owner of Italian Colors, introduced already. I got my start in the restaurant business at the age of 14, washing dishes at a Greek diner in Detroit. From there, my passion for food soon grew into a career. I graduated from the Culinary Institute of America, traveled across the country, cooking at various places, honing my craft, and settled in the Oakland, California area. And I opened my first restaurant in 1986. I opened Italian Colors in 1993, creating a quintessential neighborhood restaurant geared towards community, quality food, and great customer service. However, like most local restaurants, our profit margins are razor thin. We survive by fostering client loyalty, keeping prices low, and cooking quality food. This means that keeping costs low is also very important to our survival, something that is made extremely difficult when credit card companies don't treat us fairly. As many of you probably know, American Express cards are very popular for diners because of all the perks they offer. However, what you may not know is that American Express imposes special rules on restaurants and small businesses. In order to accept my American Express cards, my restaurant has to accept all types of American Express cards, even cards that are pretty costly for businesses like mine. American Express also will not let business offer discounts to encourage customers to pay with another form of payment. Being forced to make a decision that is bad for my business isn't right, and as it turns out, could also be illegal under federal antitrust laws. A few years ago, I described the agreement with American Express forcing on retailers like mine to a friend and attorney, Edward Zussman. We decided to challenge what American Express was doing in the court as violations of antitrust laws. My first agreement with American Express in the early 90s did not contain a forced arbitration clause. I learned that one was added as a term and condition of continued use of their cards in the late 90s. It was sent out as a bulk mailer, which looked like a credit card application, so I'm sure I just tore it up and threw it out. So after that, my attorney explained that the arbitration clause meant American Express couldn't be held accountable in court and that I couldn't join together with other small businesses who were harmed in the exact same way. Instead, I'd have to go it alone in a private arbitration tribunal designed by American Express. Needless to say, I was shocked. I can't recall ever even reading a forced arbitration clause, and certainly don't remember signing one. But even if I knew the clause was in the fine print of the contract, it wouldn't matter. American Express contracts are offered on a take-it-or-leave-it basis. It's their way or the highway. As my case moved forward, we learned that the cost of individual arbitration was so high that even as a small business won, it still lost. An expert testified that it would not be cost-effective for any small business owner to file an arbitration claim against American Express because it would actually cost more to bring that claim than they could ever hope to recover in arbitration. For me, it's about $5,000–6,000 a year that they hit us in extra fees, and the cost to do a arbitration on my own, it was anywhere from $350,000 to $1 million to try to collect what they've overcharged me for the last 11 or 12 years or however long they've been doing it. Just doesn't make sense. This cost-prohibitive system meant no one small business could ever get justice acting alone. I used to think that our legal system guaranteed the right to join with others to hold powerful corporations accountable. But because of a forced arbitration clause, I couldn't. Our case went all the way to the U.S. Supreme Court, where I thought surely justice would prevail. But when it comes to forced arbitration, justice just doesn't apply to the little guy. The Supreme Court ruled in favor of American Express and forced arbitration, saying that it didn't matter that a small business owner couldn't pursue important rights against a big business. I came here today to share my experience of forced arbitration and to speak on behalf of other small business owners like me who are struggling to stay in business and live the American dream. In speaking to you, I hope I have shed some light on how critically important this issue is across the country. Small businesses are the lifeblood of America and play a central role in creating good jobs and keeping the economy moving. But it's our employees, our customers, and our neighborhoods and communities who lose the most when powerful corporations get to push us around. But my story doesn't have to be the end of the story. I'm encouraged by the actions of the agencies like the CFPB who are taking action to help protect businesses on Main Street from businesses on Wall Street. Small businesses and consumers should have the same access to the justice system as large corporations, and they should never be able to take away our ability to hold them accountable when they break the law. Thank you very much.
Thanks, Alan. Good afternoon. My name is Joe Valenti. I'm the Director of Consumer Finance at the Center for American Progress Action Fund. And in a minute, I'll be moderating today's panel. But first, I'd like to invite our panelists to come up on stage, and I'll introduce them briefly. Deepak Gupta is the founding principal of Gupta Wessler PLLC. He specializes in Supreme Court, appellate, and complex litigation on a wide range of issues, including constitutional law, class actions, and consumers' and workers' rights. He's argued before the U.S. Supreme Court in leading cases on forced arbitration of consumer and worker claims. Before founding the firm in 2012, he served as Senior Litigation Counsel and Senior Counsel for Enforcement Strategy at the Consumer Financial Protection Bureau during the agency's historic founding. Julie Murray is an attorney at Public Citizen Litigation Group, where she's worked since 2011. Her practice areas include administrative law, the First Amendment, civil rights, federal procedure, and open government. Before joining the litigation group, Ms. Murray served as the Margaret Fund Fellow at the National Women's Law Center in Washington, where she focused on the rights of women and girls in schools and in the workplace. David Halperin is an attorney and advocate, and his career has spanned a number of politics and policy roles. including having served as the founding director of Campus Progress and senior vice president at the Center for American Progress, senior policy advisor for Howard Dean's presidential campaign, founding executive director of the American Constitutional Society, and a White House speechwriter and special assistant for national security affairs to President Bill Clinton. And finally, Vildan Teskey is partner at Teskey Miko, PLLP in Minneapolis. She's spent most of her legal career advocating for fair and just business practices in consumer transactions. She's represented consumers against major corporations, as well as other businesses that contract with consumers. And as part of her consumer financial litigation practice, she represents our military men and women in Service Members Civil Relief Act matters and individual and class actions.
Start with you. So we've briefly talked about the Federal Arbitration Act, which is a law that dates to 1925. How did we get here? How did a law passed by Congress almost 100 years ago have such an outsized influence today?
Yeah, so for most of the 20th century, the Federal Arbitration Act was a pretty boring law. It was passed in the 1920s by people in Congress who really wanted to allow businesses with equal bargaining power to resolve their disputes outside of court if they wanted to. And there's nothing wrong with that. I don't think any of us have anything against the idea that if Google and Facebook want to have somebody who understands their industry settle their disputes outside the court system, they can do that. And so for a long time, that's all the Federal Arbitration Act meant. It wasn't until the 80s and the 90s when courts started to feel pressure on their dockets that businesses started to impose arbitration on their consumers and workers. And it wasn't really until the past decade that you had the Supreme Court splitting in all of these cases 5-4, and the arbitration law really got quite aggressive. So you had cases, several of which Justice Scalia was the author of, all decided 5-4. One decision called Rent-a-Center said that even when someone's challenging an arbitration clause, the arbitrator gets to decide whether the arbitration clause is fair, which is pretty strange, right, if you're challenging whether the process is fair. Then in a case I argued, AT&T versus Concepcion, the Supreme Court held that companies can use the fine print of their contracts with consumers and workers to ban class actions, to exit the civil justice system, particularly in cases where the only way to get redress is through a class action because you have small dollar claims. And then I think Allen's case, Italian Colors versus American Express, is kind of the high watermark. Again, a decision by Justice Scalia. And for those of you who maybe don't read court opinions all the time, please read Justice Kagan's dissent in that case. It's a beautiful dissent. And what she says is, look at how crazy this is. This is an antitrust case. It's a case about people's ability to challenge people with market power. And they're using that very market power to ram down in their faces a contract that prevents them from challenging that very market power. She says it a lot better than I just did. But that is sort of the high watermark, and I think it shows why the solutions were never going to come from that conservative majority in the Supreme Court. They're going to come from legislation like Senator Franken's legislation or from the various things that the administration is doing in a regulatory capacity.
So Justice Sandra Day O'Connor over 30 years ago warned about arbitration going down this path. What's happened at the court? Is there a way to explain how this dynamic has changed?
Well, I think it really became, and this is, we're talking about the court up until Justice Scalia's death. Of course, we don't know what's going to happen now. But it really became a court that was against litigation as a tool for solving problems in the market. And so you saw this across a range of areas where the court limited class actions, they limited the ability of people to band together and to go into court. And the arbitration jurisprudence, I think, was one part of that. And it really took a statute, it's just a few words in a statute that just said arbitration agreements are enforceable. And it used to be that you could use, there's a legal concept of unconscionability that people learn about in contracts law. If a contract is unfair, you could challenge it as unfair. And what the Supreme Court said in the Concepcion case was basically, no, states can't use their regular contract law to police these unfair contracts. Instead, in what is really a big power grab for federal law, the Supreme Court federalized the whole area and said, no, inherent in the idea of arbitration is the idea that it has to be one-on-one. It has to be, the little guy has to go up by themselves against the corporation. Even though, of course, we know that in the 1920s, Congress had nothing of the kind in mind.
So just to clarify for folks who are here, or folks who are watching our live stream, Julie, what's the difference between class actions and individual actions, and why is that such an important distinction?
Right. So when most people think of litigation, you think of an individual plaintiff who goes to court and sues, one or more defendants, and that's sort of the typical case. You can also have cases that might have small groups or medium-sized groups, 20, 30, maybe even 100 plaintiffs who are themselves named plaintiffs. They're all in the case. They are corresponding regularly with their attorney. Each one of them has the veto power or decision to settle a case. So even though the case is a single case, there are multiple named plaintiffs in that case, and they're all participating in the litigation. A class action is different in that in order to get a class action, plaintiffs actually have to use either in federal court, Federal Rule of Civil Procedure 23, or one of the state analog rules, that it is a procedural mechanism for getting lots of claims together where large numbers of people have been injured, but it just wouldn't make any sense for all of them to come in and be named plaintiffs in a case. And so in a class action, you have maybe a handful of plaintiffs standing in for hundreds, thousands of other absent class members who are not actively involved in the litigation and may not learn about it until later on in the litigation. There are a number of procedural mechanisms that courts use to make sure that the class action is fair and those absent class members' interests are adequately represented. But that's in terms of thinking about what impact does forced arbitration have in different contexts. I think that's an important distinction to keep in mind.
So Congressman Byers spoke about the value of arbitration and dialogue. Deepak, what's the difference between forced or mandatory pre-dispute arbitration and other forms of arbitration that are out there?
Yeah, I mean, I think, and I said this earlier, right? I have nothing against the idea that if somebody thinks that there's a person that knows their industry better and they want that person to decide that, we can get together and we can decide. We could get together and decide to use rock, paper, scissors, shoot. We can decide whatever we want. But forced arbitration decides even before you know what the dispute is. Even if most of us, when we buy a product or service or we get a job, we're not thinking about suing the person, right? We assume that we have some background legal rights. And so what's pernicious about forced arbitration is it makes it a take it or leave it condition of getting a product or service or taking a job, or increasingly we're seeing this with schools, for-profit schools inserting these clauses, where nobody has any real choice. And so, and then that creates a lot of pernicious effects. If the arbitration provider, which is selected in the clause, knows that it depends on being selected for their repeat business, you're going to see structural problems where there's a repeat player effect and the outcomes favor the people who draft the clauses. They get to set the rules. They get to pick how the arbitrators are selected sometimes. They get to pick a distant forum, or they might impose prohibitive costs on the person who's seeking access to the forum. So all of those are problems that don't arise if after a dispute has occurred, you and I get to pick how we want to resolve our dispute.
David, I'll turn to you. How can our viewers today or other folks out in the marketplace determine if they are affected by these clauses, and who is affected by these clauses?
A lot of us are affected. May I just say before I answer you, something is on my mind. I'm very glad to be here. I worked here for many years. I had a colleague here, Cassandra Butts, who passed away, and we're going to say goodbye to her later today. And the reason I bring it up is not just because I'm thinking about her, but Cassandra was the head of economic policy here at CAP, then she was the head of domestic policy. And events like this and work that's done here at CAP on issues of justice and opportunity are a tribute to what Cassandra built and the work that she did here. So I just wanted to say that for the folks here and anybody else who might be watching, we are thinking about Cassandra. A lot of folks are affected by arbitration and you don't know it. The statistics that were presented by the members of Congress who spoke, if you have a credit card, if you buy a timeshare, if you do a lot of things interacting with large companies, if you're a franchisee dealing with owning a franchise. The example that I know the most about, and I've been involved with dealing with starting back when I was here and continuing today, is for-profit colleges. We live in a nation of Trump universities. In fact, these schools are worse than Trump University because the students are poor and because the taxpayers, in addition to the students, are taking a hit from these schools. Who are the typical students at a for-profit college? There are low-income people, returning veterans, single parents. They're people at a total mismatch with the corporation that is not only working to try to separate them from their money in the way you've heard in recent days about Trump University, but they just couldn't possibly know what they're getting into in terms of the deceptive pitch, and they don't know that somewhere in that contract that they sign it says you're going to be stuck with forced arbitration. So it's part of a system where increasingly sophisticated lawyers, and some of them maybe actually be in this room attending this event or watching, have figured out, and you can read in the New York Times in part how this was done, how to structure contractual arrangements with consumers in a way, just as Congressman Beyer had to take it or leave it at the Best Buy, take it or leave it in all kinds of contexts. If you do see it, there's some opportunities to try to cancel it, but often you have no opportunity, and you could argue with them and they'll say, look, I just work here, pal. I can't change your mandatory arbitration agreement. So it's something that takes advantage of the mismatch between a consumer with little information and a corporation that is working hard to figure out how to take advantage of that consumer. And what it leads to, unfortunately in many contexts, is impunity, where people can act badly and get away with it, and as was discussed earlier, there's no finding out what happened.
So I wanted to dig into that a little bit. Vildan, I'll turn to you. I think many people watching may not believe that in some of the horrific cases we've heard about from Senator Franken, Congressman Beyer, and others, where someone loses their life savings, or you've got a nursing home patient who's not receiving proper care, that there should be some opportunity to get out of forced arbitration and into a courtroom. Is that the case?
Thank you, Joe, first of all, for having me here today. No, once there is a forced arbitration clause in the contract, it's almost impossible to get into a court. You can file the case in court, but it will almost surely be moved back into arbitration. So there really isn't an opportunity to get out of it. Once you have that in your contract, you're stuck with it.
What if an arbitrator gets the law wrong?
There is no appeal. I mean, in a court case, you get a chance to have a panel of appellate judges take a look to see if the lower court judge got the law right or wrong. In arbitration, that's not an opportunity. You have lost that right to have appellate court judges look at it.
So I'm going to open this up to the entire panel. So what ultimately are the consequences for individuals and for the broader economy?
Well, I mean, I think, let's think about this in terms of our democracy. We think that we have Congress to write laws because, something is important to society. Civil rights, the rights of consumers not to be mistreated by lenders, whatever it is, antitrust laws. And we sort of assume that we have these laws and that they're enforceable. But arbitration should be regarded, I think, as a threat to the rule of law. Because inherent in the rule of law is that you have the right to vindicate those rights. A case produces precedent, and then like cases are treated similarly. We learn publicly about what happened in that case, and that's what law consists of. And so arbitration is really a threat to democracy and the rule of law. I don't personally plan to sue credit card companies or cell phone companies or cable companies, but I assume that they're constantly thinking about all sorts of creative ways to rip me off. And what I hope is that somebody somewhere is incentivized to figure out what those problems are and do something about it, not because I want the check in the mail, but because I want some deterrence in the system to make sure that the law is actually enforced.
If you don't have access to the court system, you've just lost all sorts of protections. I mean, there is a whole body of federal and state law that you can't enforce on behalf of consumers and service members and employees when you don't have the right to go to court. And the 200 years of jurisprudence that have led to all the substantive and procedural protections that we have in our court system, like discovery, like having the right to appeal, among a number of other rights, those are gone. And so it has a major impact on everybody. I mean, there is not a single person in this room who is not impacted by forced arbitration. Every single one of us has contracts. And throughout our adult lives, we will be entering into contracts, and the majority of those contracts will have forced arbitration. And I think the majority of the population thinks, oh, if this company does something wrong, or if I'm hurt in some way, I can go to court and get justice. That's not the case.
I will go back to my favorite example again, which is higher education. Almost all of the bad for-profit colleges have been forcing students into arbitration. No legitimate nonprofit college does it. It's not just if you get deceived enrolling. If you're attacked on campus by a university employee, again, that's all forced into arbitration. Look at an example of Corinthian colleges, one of the worst for-profit colleges. It's now been shut down. It was getting $1.5 billion a year of your tax money. $1.5 billion, not million. For student aid. And because students had grievances, they were ripped off. The quality of the education wasn't good. They were lied to, but they couldn't sue. That wasn't just bad for the individual student. It meant that even if they could get a lawyer to go to arbitration, which lawyers often were reluctant to do, the arbitration was secret. So other students wouldn't find out what was going on. The government wouldn't find out what was going on. What was the result? Corinthian ultimately collapsed when when congressional investigations, media investigations found out what they were doing. What happened then when Corinthian ultimately was cut off from federal financial aid? They said, we don't have any money. We have no money to pay back even the law firms and lobbyists that we hired, let alone all the students that say they were wronged. Who's going to pay for the Corinthian mess? We are. Taxpayers are going to pay. So the whole system is ripped off, the consumer, the government, everybody, because their abuses were kept under wraps, and they were kept under wraps because nobody was able to sue when they had a complaint.
So it sounds like arbitration clauses lead to a set of conflicting incentives. Is that something that folks would characterize as being true?
Well, I think that it certainly leads to an incentive for companies to do as much as they think they can get away with. And I think David's point about regulators, the importance of having access to the court for regulators is a really critical one because, for example, the CFPB and looking into arbitration, one of the things that it studied was, is the private or is the sort of public enforcement model enough to make up for the fact that consumers can't get into court? Is it, are state attorneys general and federal regulators doing the work that lawsuits used to do before forced arbitration? And one of the things that it found is many of the cases out there brought against consumer financial companies, they had no analog in terms of what the government was doing in enforcement. And in other cases where the government had taken enforcement action, it lagged many years behind what consumers had, when consumers had raised the red flag in litigation. That certainly happened in Corinthian. So I think that, when you have a system where there is a lot of secrecy, not just because the proceedings are private, but because many of these arbitration provisions actually have a gag clause in them that forbid consumers from even speaking out about what happened to them in arbitration. Absolutely, you create an incentive for companies to get away with what they think they're able to, and in the absence of any transparency, I think you're going to see a lot more corporate wrongdoing.
So you mentioned the Consumer Financial Protection Bureau, which has released a proposed rule very recently, has done a lot of research on this issue. What is so important about its research and its findings?
Well, for a long time, because these clauses make the proceedings secret, for all the reasons Julie gave, it was hard to make empirical claims about arbitration. Consumer advocates, employee advocates were convinced that it was unfair. And a lot of the debate was about the outcomes. Are the outcomes different from court versus arbitration? I think the CFPB study really changes the debate because it's the single most comprehensive empirical look at arbitration. It's, 900 pages, something like that, with appendices. It's a magnificent piece of work. It really shows you what a federal agency can do when it has the power and resources to study a problem. They went to the largest arbitration provider, the American Arbitration Association, got all of their files, looked through all of them, and it reveals the argument that the industry makes, which is that arbitration is some kind of faster, better, cheaper alternative to the court system. It reveals that to be a bad joke. The CFPB looked at, how many consumers with small dollar claims actually go to arbitration each year. And they found that for claims of under $1,000, which is the prototypical claim for a consumer class action, that you're talking about 25 people a year. And the number of people who won affirmative relief of under $1,000 per year was about 4 people. So it's not 4 million people, it's not 400,000 people, it's 4 people. And but on the other hand, every single person in this room and virtually every American is subject to these clauses, and the class action system delivers billions of dollars to tens of millions of people. So if that's the cost-benefit analysis, there are no longer any good arguments on the other side that this is a faster, better, cheaper system. So I think the CFPB study really blows the lid on a lot of the industry arguments.
Is there anything in what the CFPB has done or in what you've seen about how vulnerable populations in particular are targeted by arbitration clauses?
One of the things that, sorry, go ahead.
No, I was going to say, one of the populations that I represent is service members. There is a federal law called the Service Members Civil Relief Act that specifically provides for protections for our active duty military men and women. And that law has been on the books since before World War I. It's an important protection that our service members have so that when they go off and fight, for our country, they don't have to worry about certain things back home so that they can give all of their energy and attention to serving our country. The Service Members Civil Relief Act provides protections like, no foreclosure without a judge saying it's okay to do so while someone's on active duty. No repossessing a vehicle if someone's on active duty. It has protections for cell phone contracts, for auto leases, all sorts of things that service members have rights under. So what happens is all of those contracts now, more and more in the last few years, have arbitration clauses in them and class action bans. And those arbitration clauses and class action bans are making it incredibly difficult for the service member to actually enforce those rights. So what happens then? We've had this law for over 100 years, and now we can't enforce it because they can't band together to bring class actions. They have to go into secretive arbitrations, and it's a completely different system than when they're in court and a judge can enforce their rights.
Do you have an example of a service member who was harmed by one of these clauses?
Absolutely. A few years ago, I had a Minnesota National Guard member come to me with a foreclosure that happened while he was being deployed to Iraq. So we looked into the facts of the case, and we found that, yes, in fact, the lender started the foreclosure proceedings as he's being deployed and did not bother to go to court to get a court order allowing them to do so. And went ahead with the process to have the house sold while he's abroad, serving our country. And he didn't find out about this until months later when he received some paperwork in the mail while he's serving our country in Iraq. And so He came back. He didn't actually know whether he had certain protections. He contacted us after he had seen some stories in the newspaper about other illegal foreclosures that were happening to service members. So he contacted us to see if his rights had been violated. And in fact, we felt that they had, that it was an illegal foreclosure. So we investigated it and found in our investigation that this same lender most likely had done the same thing to a number of other service members, and found a report that showed that at least 80 to 100 others were known to have had these illegal foreclosures by this same lender. So we talked to him about it, and he told us that he wanted to bring the case as a class action, so that he would be the class representative, and he would then enforce these rights on behalf of not only himself, but all these other service members that had the same thing happen to them. So we filed the case in federal district court and filed it as a class action. The next thing that happened is that we got what's called a motion to compel arbitration. And that's basically the lender saying, hey, we have an arbitration, a forced arbitration clause in our contract. You can't be in court. And oh, by the way, there's a class action ban in that clause, which means you can't represent the rest of the service members. And this was a really big deal for many reasons, but to him, the fact that he knew that this had happened to a number of other service members, but he couldn't do anything about it by representing them. So he did not get his day in court. He didn't get the opportunity to seek justice in our country's court system, and instead it was forced into arbitration. And this is another example of what can happen. And by the way, that forced arbitration clause, it was in that thick stack of papers that you get at a closing that are put in front of you, sign here, no one really knows what they're signing. He didn't know that he had signed a forced arbitration clause. It was in that thick stack of papers.
So we've talked about service members, for-profit college students, other vulnerable populations who were affected by arbitration clauses.
One of the things that the CFPB study shows is, and this is following up on something David said, it's the good people in the education sector aren't using this, right? It's the worst actors. The CFPB found the same thing. So, payday lenders, which are really problematic industry that the CFPB is pursuing. Somebody mentioned earlier, 99% of them have arbitration clauses, right? It's responsible financial institutions don't feel the need to rely on these really unfair clauses to the same degree. And so I think that shows that this is really a practice that's designed to insulate the worst kinds of practices to consumers.
I would add, and try to be polite about it, that these worst industry people are not some rat living in a sewer all the time. They're fancy people in New York and Washington. They're represented by the finest law firms and lobby firms in the city who engineer these things. This maybe not the most academic point, but this is a dramatic shift of power from individuals to corporations, a dramatic shift of money from individuals to corporations, and incentivizing some of the worst behavior you can imagine in all kinds of things that affect your daily life every day, when you buy things, when you rent things, when you get an education, when you take a vacation, et cetera. So I'm very glad that the Obama administration is waking up to this, that members of Congress are taking a leadership role, and I think as citizens we have a chance right now to do something about it, to push for reforms. A 5-4 majority in the Supreme Court made this possible, that there may not be such a majority for that anymore going forward. So there is an opportunity for change. So there's a chance for hope, especially now that experts like these have identified the problem.
And we're going to turn to some of the solutions that agencies are pursuing and Congress is pursuing in a minute. But one last point before we do. Deepak, you've written recently about arbitration as a form of wealth transfer. Could you explain sort of what you mean by that?
Sure. Yeah, I mean, I think this is an attempt to kind of, so this is, you're referring to a white paper that we put out through the American Constitution Society, and it's a forthcoming law review article. It's just an attempt to kind of frame this issue and connect it up to the larger debate and conversation that I think we're now having about income inequality. And I think you can look at arbitration as something that takes away important procedural rights and access to the courts. I think there's been a lot of conversation about the issue along those lines. But if you also just look at something like the CFPB study, which shows the amount of money that is transferred to consumers when they have the right to bring class actions, it's a transfer of wealth downwards back to people who've had money stolen from them. And so it stands to reason that when an arbitration clause is used to squelch that effect, that it's actually a massive wealth transfer upwards. And that's true in consumer finance. It's true when it comes to wage theft, companies cheating people out of the minimum wage. It's true if you look at cases like Allen's, where you have antitrust law that's being squelched, and so small businesses are having lots of money stolen from them out of every transaction. And so, it's just a way of maybe changing the conversation and connecting it up with the larger conversation about economic inequality. And I think it's so great, and thanks to Joe and Center for American Progress for having this event. I really feel like in the last year the conversation about this issue has changed so much. I think part of that is maybe the New York Times series, which if any of you haven't read it, please read it. Jessica Silver Greenberg did a fantastic job, and the fact that the administration is now across a range of agencies focusing on the problem.
I'd like to just contrast, I think you were hitting on this a little bit ago, contrast what we were able to do on behalf of these populations of consumers or service members and employees some years ago compared to where we have been the last few years. In my practice in representing service members in consumer financial cases, some years ago, for example, we had a case against a major lender that was not giving the interest rate cuts that the Service Member Civil Relief Act, SCRA, provides for our active duty service members. And that client brought the case as a class representative on behalf of everyone else, all the other service members that had this happen to them. And in that case, the student loans were from the 90s, before these forced arbitration clauses and class action bans became very prevalent. And so we were able to bring that as a case of several thousand service members and get money back for each one of them. And then contrast that with what we have now, where the majority of the current contracts have these clauses, and we're not able to do that. So you're having to do one by one, and most service members or consumers don't know what their rights are, don't know when the law has been violated.
So we've seen in just a few short years, the Consumer Financial Protection Bureau taking a strong stand on so many issues where consumers may not know their rights or may not feel that they have someone on their side. We saw the payday lending proposed rulemaking announced last week, which is a big step forward. And a few weeks ago, they announced an arbitration proposed rule. What would that rule do?
So the rule would ban the use of arbitration clauses to stop class actions, to stop consumers from banding together in class actions. It doesn't go one step further and ban individual arbitration altogether, although some of the proposals that have been discussed by some other agencies are going to do that. But the Consumer Financial Protection Bureau has a authority under the Dodd-Frank Act that required them to do this study, and they concluded that they had overwhelming evidence that the use of class action bans was not in the best interest of consumers and was undermining the enforcement of consumer financial protection law. So there are a lot of consumer advocates that would like the agency to go that one step further. I think the agency will study that problem, but it's a very, very important first step. And of course, there will be a huge fight over this proposed rule. There are already attempts to insert riders into legislation in Congress to take the authority away from the agency. But it's a huge step. I mean, I think for those of us who've been working on this issue It's sort of amazing to see an agency taking this step, and it's the most important thing that's happening.
Just to clarify, this is for new contracts, right? After
New
the rule goes into
contracts,
effect.
exactly. It will grandfather in old contracts. But if you run a credit card company, you're constantly changing the terms of your contract, so it's going to be pretty hard to leave those arbitration clauses
Their cards
in place.
expire, and,
Exactly.
and all of those things happen. What about the Department of Education? I know we're eagerly awaiting a proposed rule from the department. Julie, what are you looking for?
Yeah, so we're hopeful to see a proposed rule from the department sometime this month. The Department of Education, we are looking for a few things. One, as Deepak said, in the CFPB context, the agency there has proposed banning forced arbitration with respect to class actions. We're looking for a more comprehensive approach by the Department of Education that would extend to individual and small group claims as well, so that you just couldn't do forced arbitration if you're typically a for-profit college. And I think that distinction makes sense for a couple of reasons, even if the CFPB's rule stays as it currently is. One of those is that unlike the CFPB context where the agency is regulating private actors in the market, in the education context, U.S. taxpayers spend $120 billion a year on Title IV assistance, and many of those dollars are going to for-profit colleges that have a demonstrated history of defrauding their students and that are using these arbitration provisions. So I think having a more comprehensive rule in the education context makes sense for that reason alone. But I think it's also the kinds of claims that come up in the education context are somewhat different from what you'd see in the consumer financial context. Most of the CFPB, the transactions that are going to be covered by the CFPB's rule, a lot of them are very small value claims that it really doesn't make any sense to bring those claims. No one would do it without the class action mechanism. That's not necessarily the case in the student context. We've looked, for example, at some of the data about the very few students who brought claims against Corinthian colleges in arbitration. Like David said, that school has now collapsed and gone bankrupt. But during a period where we know, there were lots of investigations going on against Corinthian, from 2011 to 2015, only 71 students brought claims against Corinthian in arbitration. So we know that's not because thousands of people weren't injured. Only 71 brought claims, and only a single student actually got a monetary award in his or her favor from an arbitrator. So one person over years of wrongdoing got a monetary award in his or her favor. But another thing that's interesting that came out of that data is that the median claim value was $75,000. So I think you could imagine a situation in which a single student or a group of 5, 10, 20 students could band together, and it would make economic sense for them to do a case in court. And in fact, when you look at the cases, many of the cases that students are bringing are not class actions. They're small group actions. And so I think, we really want to see the Department of Education take a more comprehensive approach. The other two things that we're looking for is making sure that the claims covered by the Department of Education are sufficiently broad. One, because we think it's important to have a more robust response from the Department of Education, but two, because the more ambiguous the scope of the rule is, the more likely, as Deepak talked about, some of these contracts are going to allow the arbitrator, if there's a dispute as to what's covered by the arbitration provision, that's going to an arbitrator. And so we think that for clarity purposes, it's really important to have a comprehensive approach and to cover all students at schools that are receiving Title IV dollars, not just federal borrowers.
In the education context, we've had a number of students from these for-profit colleges contact our office to see if there's anything that they can do, and almost uniformly those contracts have the forced arbitration and class action bans, and so it changes the way that you can advocate for these students. when they can't band together.
There's one more trick that was tried last year when a school bought the Corinthian campuses and said, under pressure from consumer advocates, we said stop forcing the students into arbitration. There's a company called ECMC, now have their Zenith unit. And finally they said, okay, we won't force students into arbitration. When the enrollment agreements appeared around the country and we got them, it said, okay, you don't have to arbitrate, but no jury trial, no class action. So the devil is in the details. And when University of Phoenix announced last week they were going to stop forcing students into arbitration, and they reached out to me and said, hey, isn't this great? And I said, are you going to ban jury trials and arbitration? They said, we'll get back to you in an hour. They still haven't gotten back to me. So watch what they say very carefully and what they do.
And this all really comes down to the Seventh Amendment, right? That the right to trial by jury.
But you can sign it away by contract, and the Supreme Court will uphold it, or at least the previous Supreme Court.
So we see lots of action on the regulatory front. We have CFPB, we have the Department of Education coming out with something soon, Centers for Medicare and Medicaid Services on nursing homes. The Department of Labor has already banned limitations on class actions against financial advisors and its fiduciary rule, something that I was really, really glad to work on. Now, what about Congress? Senator Franken mentioned a couple of pieces of legislation. We see bills designed to limit the use of arbitration clauses. On the one hand, we see the budget riders that you've alluded to that have tried to block agencies from limiting arbitration. We saw some of those in the run-up to last year's budget deal. We very well may see them again. It sounds like Congress is of some very unlike minds on this issue. Does anybody have any thoughts on sort of the prognosis in Congress, or where this difference of opinion might be coming from?
I mean, I don't know if it's possible to get anything done in Congress right now.
On any issue.
On any issue. But we have had some success, and it's worth looking at these examples. In the military context, there was something called the Talent Nelson Amendment, which led to the Military Lending Act, and that authorized the Department of Defense to ban arbitration in consumer lending contracts with members of the military because the Pentagon concluded that it was a national security risk. And that was bipartisan legislation. It was attached to the must-pass defense authorization bill. I think that shows when there's a politically favored group and people come together and they're focused on the substantive problem that the arbitration clauses are furthering, that some progress can happen.
And President George W. Bush signed that into law.
Exactly. Right. And the Dodd-Frank Act, banned arbitration clauses in mortgage contracts. Of course, they weren't really there anyway because Fannie and Freddie weren't allowing them. But that's some progress.
But they were in other contracts.
Right.
I mean, if they were not a Fannie mortgage contract, like my client had one,
right.
And it was legal for them to have that forced arbitration clause. So I mean, there are certain pockets of contracts that can't have the arbitration agreements, but there is still a vast majority of contracts out there that can.
Yeah, and if it's not okay for your client who's being deployed to Iraq, and it's not okay, for consumers in financial contracts, and it's not okay in the Department of Labor context, it starts to really chip away at the whole edifice. And then I think, I think then there's a possibility of something like Senator Franken's bill passing.
I also have to add another effort right now is to clarify under USERRA, which is the federal law that protects the employment rights of our veterans and our service members. Senator Blumenthal has proposed an amendment to clarify that they have the right to go to court if their employment rights have been violated. We'll see what happens with that, but it's definitely a step in the right direction.
Anything else on Congress?
Just shake my head.
I mean, we do see there is the Defense Authorization Act debate this week that Senator Franken mentioned around the rights of defense contractors. Anybody have any thoughts on that?
I think that's a great issue because it really highlights how pernicious this practice can be. We're talking about the ability of defense contractors to prevent people who have suffered sexual assault from going to court to hold their people who have committed really heinous acts against them accountable. So I think Senator Franken was right to pick that issue early on in his time in Congress, and I hope that there's some attention to that issue.
Is this a money in politics issue at all? Anybody want to comment on that?
It absolutely is. It's about, free markets have been replaced by Washington, and you get things by lobbying and litigating, and the results that might have occurred in a society where Washington didn't control all these things would be different. So people who can't make a credit card product that actually would help consumers and make consumers want to use it, instead hire people here to make it so that everybody can make a bad credit card product, but consumers won't really know it. And so all of this stuff is money in politics. And I don't spend a lot of time on the structural things like trying to ban speech and figure out how we're going to possibly restructure campaign finance, although I do think that's important. I'm more about, in my work, highlighting the abuses that go on, the inequality, and try to force enough outrage through the media, through sympathetic members of Congress, through the administration when there's an administration that cares, to get change on the specific issues where there's inequality. And arbitration is one that cuts across a lot of different substantive areas of the economy where consumers and workers are taking a hit. So it's one where you could actually get a lot done across a lot of different problems if you could bring some reforms.
So I'm about to open it up to the audience, who's been extremely patient over the past hour plus, but I did want to give the rest of the panel a chance for any final thoughts.
I'll just say this. I mean, we hear so much from the industry saying, arbitration is great, it's, fast, cheap, etc. Why not, if it's so great, why not make it voluntary? Why force it? Make it so that each side gets to choose whether they want to be in arbitration or if they want to be in our country's court system. And that's not happening. It's not voluntary, and the reason is it's one-sided.
I think that's right. I think, it is the case, not only is industry saying it's fast, it's cheap, but this is actually better for consumers. And I think, the best person to make that decision is the consumer at the time that a dispute arises. And so, what's the harm in letting students and other consumers make that decision at a point when they can do it with their eyes wide open and know what they're signing away?
Final thoughts?
Yeah, I think it's one of those issues it's so important and so it's so difficult to make progress on. It's amazing that as much has happened as it has, because it's about these things that nobody knows about, that nobody knows that these contracts exist. Even the words forced arbitration, it's about federal preemption of state law and all that. It can be very esoteric, and so it's difficult, I think, to get across to people that this matters. And there have been some attempts. There's a short film, a 20-minute film that I recommend people watch called Lost in the Fine Print, that attempts to show people's real stories and how people are really affected. I think things like that New York Times article really made a difference, again, because it showed how real people's stories, people like Alan and his business, are affected by this practice. But I think it's a very, very difficult issue because it's a structural problem, because it goes up against very powerful industry opposition. And so we're really going to need to have people in rooms like this who are in Washington need to then get out there and tell a lot more people about this problem. There needs to be a lot of public education. Because something is wrong when there's a practice that when people are informed about it and they understand it, everyone is against this, right? Unless you're trying to screw people over with these clauses, you're against this. And yet it's completely ubiquitous and prevalent. So that's a public education problem.
So I forgot to mention earlier, I know we've had a robust conversation, not just today, but in prior weeks, on social media using the hashtag Ripoff clause, which is one way of describing what this is. I would like to thank our panelists once again. If you can join me for a quick round of applause, and then I'll open up the questions. And one note on questions, if you are selected, please do identify yourself. Sure. In the Michigan hat.
Go blue.
Yes, go blue. I have a very practical question, and that is, because I do a lot of this issue advocacy with members of Congress, and this actually does work to educate people, and that is, can you please give the bill numbers of Senator Franklin and Congressman Byers' bills so that we can encourage people to actually call their members of Congress to ask them to co-sponsor this legislation. So what are the bill numbers?
Oh, can you just give us your name, please, sir?
Oh, I'm sorry. My name is Stephen Spitz.
Great.
I don't know offhand. I mean, we can certainly.
We can definitely get that.
Yeah, if you Google, Arbitration Fairness Act, the first thing that comes up in Thomas would be. Nobody knows the bill number. No. There we go.
It sounds like 2087 and 1133. Okay.
Thank you.
In the woman on the right.
This is not working, is it?
No, we're here.
It is now.
Thank you. Araceli Panameño with the Center for Responsible Lending. Can the lawyers on the panel tell me if an arbitration clause is written, in contracts are mostly written in English, but service providers are marketing in the native language of consumers, whether I have a standing leg against it?
There are cases that have enforced those clauses even when the consumer can't understand the language.
Yeah. I think if the rest of the contract is in English and the forced arbitration clause is in English, courts will enforce it.
What if the entire contract is in Tagalog, even though we're in the United States? I mean, do they even have an obligation to make it in English?
There are some limits, right? I mean, there is still some ability to get the clauses struck down under background state law, but those are at the outer margins. And I think your example is a really sensible one. The fact that most courts would enforce that shows that there's not a lot of room to argue against these things.
And mind you, lower courts, district court judges see the problem and see that this is not the way things should be, but their hands are tied. We have Supreme Court cases that say to the lower courts, you have to enforce these agreements. And so that's why we need the legislation that we're talking about and that the senator was talking about today.
Other questions? In the front row.
Lauren Windsor with the Undercurrent. Can you talk about the correlation between the use of arbitration clauses and industry concentration?
Yeah, I mean, I'll start. Yeah, I mean, I think, part of the problem here is that you're dealing a lot of times with industries where there's not a lot of meaningful choice. There are very few providers, and if all of those providers decide that they're not going to give you a choice in whether there's forced arbitration, then, there's nothing really that the consumer can do meaningfully to vote with their feet, right? So if I want a cell phone, I really don't have a choice. If I want a credit card, if I want a job, I'm in a town where the jobs are with big box retailers, let's say, I'm going to have to agree to arbitration because I don't have a choice. So I think there is a strong relationship with industry concentration and these clauses. And then, Alan's case, the American Express case, shows you the kind of perfect nexus between those, where somebody's actually trying to challenge market power using the antitrust laws, and they can't do it because that very consolidation in market power is used to prevent them from bringing the challenge.
But I must say, it's not that hard to spread the problem around. You can easily find an arbitration clause on the internet and just paste it into your contract, even if you're a small business. And even if you do have a choice, no one's advertising on TV. Come on into Al's car dealer. We don't have a mandatory arbitration clause. It's just, there's too many other apples and oranges to compare. So it's, unfortunately, it is like a virus that can spread.
In industries where there's high concentration, very few choices, are there antitrust remedies to bring against these kinds of industries?
Well, there are, but the American Express case shows you that you can actually prevent someone from bringing an antitrust case. And you know, the thing about antitrust law is it's very complex and expensive to bring those cases. You have to get economists to do reports about the structure of a market. And so in the American Express case, you know, that would have cost on the order of $1 million and it's just not rational if you're trying to bring a case where the average merchant has been ripped off several $1,000s. That nobody can actually bring that case sensibly. The only way to do it is in a situation where you can pass the hat around, or where, you know, private lawyers are incentivized to do it because they can bring a claim for a lot of people. So. Yeah, I mean, it is sort of amazing that companies get to use their market power to prevent people from holding them accountable for their market power.
I mean, I would say too, though, I think, you know, what's unfortunate about that is that in industries where you only have a few players or somewhere you have more, I don't think that would matter to courts looking at the issue. You know, they'd say, well, you didn't have to go to this for-profit school. You didn't have to use this bank. And, you know, in reality, I think ordinary Americans would say you're not going to opt out of the banking system altogether. You're not going to opt out of the only colleges that might accept you. You're not going to opt out of, you know, getting a credit card. And yet, as these become more prevalent, I think it is even the sort of lie of consent or agreement is becoming even that is exposed when there really aren't in some places options for companies that don't have arbitration agreements. The for-profit context, I think, is a good one. The Century Foundation recently did a report where they got all kinds of enrollment agreements from different institutions. And one of the things that they found was that among for-profit colleges getting federal financial aid, the market share of students represented by that were subject to forced arbitration agreements was 98%. So, you know, the idea that someone, if a for-profit college is their only option in their community, the idea that they're just going to opt out of that altogether, that's not a choice consumers should have to make.
No, or if you're going to rent a car, every single rental car company has an arbitration agreement in their contract, and you're not going to be able to stand at the car rental counter at the airport and
with
negotiate
100 people
that.
behind you.
Yeah, negotiate it, and I mean, and they give you this little electronic screen that you sign to the contract, and you haven't even seen what the contract says, let alone understand that forced arbitration takes away your rights, and they can cheat you out of, you know, $50 or $100.
Other questions? On the left.
Thank you. Thank you for the panel. My name is Michael Pope with Virginia Public Radio, and I was interested in asking about perverse incentives. So when Congressman Beyer was here, he was talking about the payday loan industry, the car title loan industry. 99% of those are, you know, have these forced arbitration clauses. If you look at the car title lending business in Virginia, this is according to the state regulators, about 1/3 of these loans are more than 60 days late, at which time the interest payments are supposed to stop. But then if you talk to people who get caught in these debt traps, they continue to charge interest illegally, despite the fact that they're not supposed to do that. So I'm wondering, it seems like this is an industry that has engaged in this pattern of law breaking, knowing they've got the safeguard of the forced arbitration clause. And so I'm wondering if that's something that you see in other industries as sort of perverse incentive of law breaking.
Yes, lack of accountability leads to impunity. And it's just a fact. And federal agencies are overwhelmed, and state agencies are overwhelmed in terms of doing their own enforcement. And that's why we keep saying to these agencies, you want to save a lot of money, let the private sector do the enforcing, do the discovering, do the exposing. But if you acquiesce in banned arbitration, then all of the burden of finding out about bad behavior falls on the government, falls on the taxpayer, and we just don't have the resources.
I mean, I think one thing that the congressman's points bring up that is it's an important one to keep in mind is that there may be businesses out there that don't want to use arbitration agreements. They don't want to use it with their consumers. They don't think it's good for business. But it is also harmful if their competitors have this, you know, get out of litigation free card even when they're acting with impunity, defrauding their customers, ripping them off. And so I think by forbidding forced arbitration, one of the impacts of that would be to level the playing field for upstanding businesses that want to do right by their consumers.
Right. I mean, the bad guy is not the general counsel who recommends that a company insert the clause because everyone else in the industry has it. And in a hyper-competitive industry, to say, look, we're going to be the one company that can be hailed into court in a class action for practices that the whole industry is engaging in, they're not the bad guys for sort of saying, let's avail ourselves of this legal strategy that the Supreme Court has blessed. Right. The problem is a much more systemic problem, and that's why you need regulators to step in. But it is absolutely true. I mean, for-profit schools are a great example. The card title lending industry is a great example. Again, you saw payday lenders, 99%. Companies like debt consolidation companies, or these companies that promise to repair people's credit, but they don't really do anything. They're just taking money from the most desperate consumers. Those are the companies where you see they all have arbitration clauses because their business model depends on skirting the outer boundaries of the law.
We just recently had a potential client contact us about these credit repair issues. A credit repair company promised them all sorts of things and charged them about $1,200, $1,300 for it and did absolutely nothing for this person. They contacted us, and there was not a whole lot you can do because it's not economically feasible to go and litigate a case one by one, and the contract had a forced arbitration clause and a class action ban. And this happens every single day.
I think we have time for one last question. So, gentleman in the back.
Hi, Scott McConomy with Lincoln Government Affairs. I actually had two questions. I think they're quick. Can we assume Trump University did not have a binding arbitration clause since they're in court? And second, if I'm at a car dealer, for example, and I want to try and get out of a clause that's right there on paper, what do you actually write on the contract that would legally void it?
I can address Trump. It's kind of remarkable that the world's greatest negotiator failed to put into his contract something that every other for-profit college had, but no, they didn't have it, or else his lawyers would have argued that.
And I think the fact that we are seeing what we're seeing come out of the litigation against Trump, would make you expect we would probably see similar things coming out of what would have been litigation against many other for-profit colleges, but for the fact that they have forced their students into arbitration and into gag clauses that forbid those students from speaking about what happened there and what they found out.
So, second part of your question, what can you do? Unfortunately, the congressman's example about going to Best Buy to buy, I think it was a washer, a refrigerator. I think that's the norm. Most places that you do business with will say, "I'm sorry, I can't take that out. This is just the form contract. You take it or leave it." Doing the work that I do, every time I sign a contract, of course, it's the first thing I look at, and I see it in there. And most recently, we leased a car, and it was in that contract. And I had a very lengthy conversation with the with the leasing agent, and I really feel bad for that person because they said that I was the first person in their many years of working in that job that ever brought up the issue of arbitration. And I believe that because the majority of the population has no idea what they're signing.
Although once in a blue moon, you may find an opt-out clause, right?
You might.
But the opt-out clauses are there not to be kind to consumers and let them opt out. They're there because they want to show the courts that, look, we had an opt-out clause in here, so this is fair. And there's nothing wrong with this. Anyone who wanted to could have opted out. Of course, the fact is nobody opts out.
Because you have to opt out at the beginning when you enter the contract,
within
not
30 days
at the time of when a dispute arises.
Not at the beginning. So you can't opt out on the contract itself.
Right, you have
Oftentimes you have
75 to
to
90
send a letter by certified mail to a general counsel and another state. It is far more difficult than just saying, crossing out the provision. So
but you also can't wait until you've got a problem.
Right. You can't wait until you have a dispute, but you have to wait long enough so that most consumers, even if they knew this provision was in there, they're not going to opt out.
And I have to agree with Deepak. The opt-out is not there really because they know that a lot of people are going to opt out. It's there so that they can say, oh, look, we've got a great arbitration clause. We make it easy for them to opt out. Most people don't know what the arbitration clause means, don't understand what they're giving up when they sign it, and don't know that they should opt out. So it doesn't happen.
We've talked about a lot. I know a lot of people have thought, well, arbitration, how on earth do you make that interesting or relevant? And I think our panelists have done that and have really explained in quite a bit of detail why this issue matters for everyday Americans. So I hope you can join me in thanking our panelists one last time.